Good morning, everyone. Today is Friday, February 11th, 2022. This is our first stakeholder meeting of the new year, so welcome back. My name is Shana Horton. I serve as the TABC's rules attorney. I have with me Matthew Cherry, who is another attorney for TABC, to assist me if there are some questions about the rules that he might have better information on. Today we're talking about the public health and safety rules, chapters 34 through 37. And then second, we will talk about the proposed new safe harbor chapter, which right now is chapter 49. I think it's going to stay there if we do move forward with it. Because this is the first time we've met this year, and we have considerable interest from some folks who might not be as familiar with the rulemaking process as our regulars. I just wanted to go over a few things about how this process works. Just a reminder, we are in the very beginning of the process on these rules. They have been these are draft only. We have invited you here because we think it is valuable to have an open exchange of ideas before we start the formal rulemaking process. And that starts with the proposal of the rules that the commissioners vote on. So right now it's just draft form. There is no inevitability of any of these rules being made into law. And, we're just kind of having a free exchange of ideas. Let's see, the best thing to have your concerns, make sure your concerns are heard and understood, taken into full consideration, and potentially have changes made, is to engage this early in the process. So we really appreciate you being here. I would also recommend that if you make oral comments today and that you follow up with an email to me. That's just helpful to me to have it in writing so that I don't have to transcribe or anything like that from the meeting. I just have your thoughts in writing to refer to later. You can send it to rules@tabc.texas.gov. So I really appreciate that. Also, the sooner and earlier you participate, the better. As you know, once we go to publication of proposal, it gets a lot harder to make significant changes to the rules. So please engage now. If you don't feel comfortable talking in this forum, you can talk to me anytime. You can send me an email to the rules mailbox or to my personal, my own mailbox is shana.horton@tabc.texas.gov. You can call me anytime. I am in the office. I'm happy to take calls, or if you want to come in, or whatever you want to do. And that's not limited to any certain time. So you can send an email day or night, 24/7. This is not your only forum. I would say that, as of now, we're expecting these to be heard at the March 22nd commission meeting. That's about almost 6 weeks away. So we've got lots of time to continue to work on these. So in the next, 3-4 weeks, if we need to make some changes, we can. Then after that, of course, there's an additional 30-day comment period if the rules are proposed, voted for proposal by the commissioners. And that usually ends up being about 41 days because of Texas Register publication dates. So there is lots of time left. We are still the very beginning stages, and I do appreciate all of you in your participation. I know some of the names I see at most of these meetings, and so we really do appreciate you engaging with us this early in the process. If you do choose to speak today, if you could please start with your name and who you represent. If you represent yourself or your own business, if you could let us know what kind of business it is, what kind of license or permit you hold, that's very helpful too. With that said, do you have anything to add?
Not at this moment. We're ready to get started.
That said, let's get started. We are going to start with the public health and safety rules, chapter 34, schedule of sanctions and penalties. If you have been following along with this rule package, this is the second stakeholder meeting on it. So the version that we have uploaded to board docs, it is what it shows in highlights are the changes since last stakeholder meeting. So it's the red line is all the changes in total. The highlights are what's new since the last time we were here. So if we could just take a look, one of the new things that after talking with y'all, we decided to remove that a written warning would be counted as a violation for purposes of bond requirements and forfeiture. I made some changes based on a comment that the penalty policy that is used should be the one that's in effect on the date of the violation, not the date of the issuance of the notice of violation. So I made that change pursuant to that comment. We looked into the breach of the peace rule on the licensed premises. We had thought about adding licensed premises or premises under the control of the licensee. And in looking closer at that, I believe that we have the authority under Alcoholic Beverage Code 2811 to require that of mixed beverage permittees, but not necessarily others. So we have limited it to mixed beverage permit holders. I think that's it. Right. So that's just a summary of what we've done since the last time we talked on these rules. And with that said, I know a lot of folks are eager to get to the chapter 49 safe harbor rules. So if you have questions or comments, let's go ahead and just go the whole package 34 through 37, and any questions or comments that you have on this rule package as revised. You can just unmute yourself, say your name, and begin your comment.
Hey, this is Shana. This is Edgar from Griffith and Hughes. I can either go off on individual rules, or I can just go over the summary of the issues that we have. Are you going to want to go by subsection or and take comments as we're going through each section, or are you okay
No,
with just
global
open mic? Okay, well, I appreciate that. And again, I appreciate, you taking the time and energy to, put together these things. I realize that this is a major change, trying to move, some of the code or some of the rules and modernize some of the rules. So again, we do appreciate that. And we do know that this is a hard job. So please do take our comments in stride. First of all, under section 34.1D, it talks about the written warnings that they can be used as an aggravating circumstance for purposes of determining sanctions. We have two concerns with those. First of all, the rule is missing provisions on implementation. How is this actually going to work in the field? And then two, access to discovery in the field. When you go in and settle a normal administrative case, there is a waiver agreement, and you sign away your rights, and and basically it's processed and a waiver order is issued. If you guys are going to be using the warning system, there needs to be those due process protections, so somebody is not ambushed with a warning being issued. Because this has consequences. I mean, looking at your safe harbor rule, I mean, conceivably anything could be used now as a basis to defeat safe harbor. So again, that is a major concern. I had proposed.
Can I pause you right there? Just
yes,
that. Something that's not really reflected in the rules, but that we would be working on if we do move
Sure.
forward with this. I took a look at the actual tickets that the warnings are printed on, and so if we were to move forward, we would either be adding potentially like another piece of paper to staple to it, or depending on budget, updating those ticket pads so that they have in very bright, bold lettering what your rights are, your legal rights are to appeal, and how to get more information and that sort of thing. So we're hoping that that's, not necessarily putting that in a rule, but to protect people's rights and make sure they understand the consequence of what they're signing, that would be on the ticket itself. And I think that's actually probably better for most of our regulated industry that are getting these tickets, because they're not going to go look at the rules, but they are going to look at the ticket. So that's how we were planning to sort of address that concern, because we don't want to ambush people. Understand the concern that they need to be put on notice of the fact that there are important legal consequences for signing a notice violation.
And that's fine. And again, we proposed, we disagree with that. We think the better approach is treat it like you treat any other administrative violation. You sign a waiver agreement, and we think that there should be that in the rule. As far as the access to discovery, I mean, I'll just give you a good example. You're not going to go and buy a house without having an opportunity to do an independent inspection. You're not going to go and engage in some sort of medical procedure without having full, informed consent and disclosure of what some of the issues are. Whereas the reality is, in the field, rarely, if ever, do you have access to any of the discovery. And Mr. Cherry can attest to that. We've had resolved a case with a package store where we did not have a right to see what was in the TABC case file. And so that is, I think, really, I don't know what the word is, shady. I mean, one of the things that the commission, does tout is that, there's integrity and accountability and transparency. But whenever you do hide that information, I think it really builds distrust. Number two, if we were to get that information, we would essentially have to ask for a hearing. And that increases the costs for any permittee or licensee. There's also the risk. The legal division will say, well, you know what? This field settlement you got, it was too lenient. I'm sorry. We're going to be asking for twice or three times as much. And so when you look at the agency's, statement of, being easier, helping small businesses, it just doesn't ring true if that's how the field settlements are going to be working.
This is Ryan Hughes with Griffin Hughes. I just want to echo what Edgar said regarding the waiver orders. I think those are imperative because with the waiver order, the permittee is choosing to accept settlement rather than go to hearing. With the administrative notice, them just signing the administrative notice, an agent could show up with multiple administrative notices for different alleged warnings that the permittee had no idea about. That's why the waiver order is so imperative, because the permittee should be able to request a hearing on that warning, since it's an aggravating circumstance.
And I'm willing to pause for a moment to see if anybody else wants to chime in on this. Otherwise, I'm willing to go on to the next issue or issues that we see.
This is Keith Coleman. I'd like to say something about the warnings.
Go ahead.
When I worked at TABC, generally the instance when we would write someone a warning was when we didn't have enough evidence to really make a good case. We knew they did it, but we wrote them a warning because usually some element in the case was missing. And so you're going to wind up having people adjudicated for a violation without a penalty. That's really not a warning. A warning is, we think you did this, don't do it again. That's a warning. You're just removing the penalty from a legally found violation. And I just, it doesn't seem very fair.
Hey, Shana, Lance Lively with the Texas Package Stores Association. I just want to echo what the previous witnesses or commentators have had to say on this particular subject, and I'll have more later on other areas. Thank you.
This is Amy Harrison, and I also want to echo Edgar's comments. In fact, more so the appreciation of this dialogue. But when it comes to the warnings, this is sort of being perceived as an I gotcha. And I don't think the administration wants to be perceived as an I gotcha. But one of the things I found while working internally is that nobody really was very honest about their feelings about some of the things that were happening. And so I'm very appreciative of this dialogue and the fact that people are speaking up. But the agency as a whole, this administration seems to be moving away from transparency. And this rule, quite honestly, supports some of that feeling by industry members, that there's a lack of transparency, as well as you are causing permit holders to incur cost to just prove their innocence. And so there seems to be a disconnect in reality and the rules. And the fact that, from my perspective, what I'm seeing internally is there is a real disconnect when rules are passed and then procedures and forms are created. There's either a lack of education or a lack of understanding. But to have this in a rule and then us to be sitting here waiting to understand your procedures and how the forms may be created that will educate people is concerning, because it's currently not happening. There's a lot of great rules out there, but when you look at the forms and the applications that are being created, they're not reflective of that. And when you seek guidance from the agency, a lot of the employees are not well trained on these. So thank you.
This is Edgar Korzenowski again from Griffith and Hughes. I'd like to move on to the next areas. I'm looking at 34.2D and 34.103C. They're essentially parallel rules. Basically, the rules say that the legal division has essentially the authority to deviate from sanctions. They can use it as a guideline, but it's not required. I have two issues about this, actually several of them, but first of all, this seems contrary to what the state statutes say. You look at chapter 5.31 B of the code, it talks about that the commission shall ensure consistent, predictable, and timely enforcement of the code. And then you have chapter 5.362, which talks about developing a determinative penalty scheme for common violations. And that chapter came about as a result of a sunset review from 2007 that criticized the agency for being inconsistent. And so when you have cases forwarded to the legal division, you're basically saying, well, we don't have to follow that because, you know, we're a special magical arm of the agency. And because of that, we can arbitrarily, not follow that. And there's just really not a good reason for that. The legal division is an arm like any other part of the agency and should be accountable to the executive director. And for them to just say willy-nilly, we don't have to follow that, just seems wrong. But the other part of this issue is, and this is echoing the concerns about lack of transparency. One of the things that the commission did before the website, or had before the website redesigned in 2020, is listed all the agency orders that came from SOA. And so the public could read, where did the commission succeed and where did the commission fail, as well as what is the going rate. And since that redesign, this has been removed. And this is important to note because under the law, Texas Government Code 2001.004, the agency is supposed to keep an index, and they don't. But then you go and look a little bit further. When you look at some of the cases, particularly the last year or so, the agency no longer includes, when they settle cases, what was the going rate. So if you, for example, settle a case in SOA, before it goes to hearing on the merits, it just says it's resolved. So again, the public is deprived of knowledge of what the going rate is. And compare this to, another agency, the TTB, which is a federal agency. They post what, decisions come out, what some of the penalties and sanctions are. And so again, if you're wanting to have integrity and accountability and transparency, I think you need to have, first of all, consistency, and two, show the public what you're doing. It's not a private agency. It's not a good old boys club. There needs to be openness. Now, I'm not saying that this is anything intentional. I'm just saying that this is something that needs to be considered because, the agency does serve the public after all. It's not there just to serve itself. Thank you.
This is Amy Harrison. I just want to echo Edgar's comments about predictability, timeliness. An interesting thing is this rule speaks of the legal division, and perhaps I haven't checked of late, but if you go look on your web page at your organizational chart, there is no legal division. So that's what I'm talking about when you pass rules and there's a disconnect in implementation. People can't figure out who the legal division is. If you go look at the web page and there's no phone numbers, you could call the main line or hope that you have Amy and you can call and ask her everybody's phone number.
And this is Ryan Hughes with Griffith and Hughes. I just want to piggyback off of what Amy and Edgar said. So the informal policy the past couple of years is for the TABC to sit on cases where it's missing elements. The permittee cannot submit a request to docket or set a hearing with SOA. The TABC has to do that. And so the TABC is basically, after the permittee has requested a hearing, been sitting on it for years, sometimes 3 to 4 years without setting it for hearing and just saying it's under investigation. And so that's why I think the statute of limitations that Edgar proposed in his official written comments is extremely vital for permittees, and it would help increase transparency.
This is Edgar Korzenowski, Griffith and Hughes. I have some comments on a different subject. This has to deal with 35.1A, B, and G. Shana had mentioned that the breach reporting allowed the consideration of mixed beverage permits, and so that's why you're putting that in there. And I'm not disputing that 2811 allows this or not. My concern is, first, there's a lack of consistency. So you're going to have one category of restaurants, for example, that will have to report, and another category that will not have to report. And this creates confusion in terms of a clear, consistent message. I mean, if there is a legitimate concern that locations need to basically beef up the reporting, again, we're not here to dispute that, but I think it needs to be applied consistently. And I think the code does allow the agency to do that under 5.31B to, again, consistently, predictably, and timely enforce the code. And then two, if you are going to impose that, that you tell people on the front end, what are the elements of control? Is it, just the shared parking lot? Is it what's in front of you? Is it what you lease? Going back to the problem with the warning. So you don't inform somebody, you're going to issue a disciplinary warning, letting them know, well, we got you. And then, that's not fair, because then it has implications again in your proposed safe harbor revisions that basically allow you to consider anything and everything under the sun to disqualify somebody from safe harbor. So, our recommendation would be either to remove this provision, or number two, if you are going to include the premises under control, it is for all permits and licenses, and then explain what that means as far as direct or indirect control. Because again, I think 1149 definition of the premises does give the commission flexibility to impose discipline based on the control of the premises. Thank you.
This is Kelsey with the Restaurant Association. I'll just echo, we do share some of those concerns. I think under control is a bit vague, especially when you think about kind of joint parking lot situations. Are you assumed to have control over the whole space? What if the person never even came into your restaurant, got drunk somewhere else, and then had an incident in the parking lot under your control? Would you even know about that? So some concerns there.
Let me just respond to that, because that would be, we certainly wouldn't want people to be responsible for reporting something when the restaurant's closed and no one is even on the premises. But if you read the full rule, let me go on down here. You'll see that there is an exception, essentially an exception, that you may not be held administratively liable for failing to report if you can demonstrate that you had no knowledge, nor in the exercise of reasonable care should have had knowledge of the alleged breach of peace. And it says on the licensed premises, but that might need to be changed depending on what we decide to do with this. But that's not our intent, and so we would try to loop that into that subsection H. And then there are only certain things, obviously, that have to be reported. And if there's overlapping, I think it is our intent, though, that if there are, 3 bars that share a parking lot, that each of those 3 bars, if they're open and they have reason to have knowledge of the incident in their parking lot, that they would all have that duty to report. That way, hopefully at least one of them would, and we'd be able to get out there. So do you have anything to add on that? You just looked up. So.
I mean, no, not specifically. For our thoughts when adding this in is supposed to be an out for those instances where if a business was not open or that patron never visited their business at all, and they wouldn't have had any way of actually having any sort of real knowledge that an incident occurred. This was our intent to be an out for that, to cover that type of scenario.
So if you could look at subsection H, people that have that concern about, what if this and what if that, and we didn't know about it. If you could look at subsection H, and if you have any specific edits or amendments that you think would address your concern, that would be really helpful.
Got it. We'll take a closer look at that and maybe suggest some tightening up there.
Oh, thank you.
And Shana, the other concern, and this is just kind of related to this, is this sounds also like burden shifting. Whereas if you tell on the front end what you're looking for and what is required, and a permittee or licensee fails to comply, that's easy, right? Because people know what the rules are. But whenever you're putting in this condition, it's like, well, you didn't know, or something else, you're basically shifting liability back to, or shifting this burden of or defense back to the permittee. And so I just don't think that that's fair. Just tell us what the ground rules are. I mean, I think it's great that there is a part I didn't know defense if you know what the ground rules are, but I think they need to be laid out pretty clearly. So that's all I have to say on that one. Thank you.
And I think we can probably, look to case law to find a definition of under control that would work for us. If anybody out there has done such research or wishes to engage in such research, we would appreciate your input on that. I imagine that it's been litigated in other contexts, maybe even in the alcoholic beverage context before, and we could use that as a guide, perhaps, to better define what we mean by that.
This is Edgar Korzeniowski from Griffith and Hughes. I'm ready to go to Rule 49 unless somebody wants to jump in and any of the other rules under 34.
Thank you, Edgar. Let's thanks for sort of guiding that conversation through 34 to 37. Before we move on to item number 2 on our agenda, which is the safe harbor proposed rules, does anyone else have comments or concerns about any of the item 1 rule package that they wish to bring up right now? I see Judy Bracken is unmuted.
Yes, hi. I just had one brief comment, and it has to do with the regulatory schedule on the I'll get the exact number, but not the public safety violations, but the regulatory violations. Let's see, 34.10, I guess we're calling it now. I would just like, so, and I guess this could apply to the public safety violations too. You know, a lot of clients, they mess up the first time, and there's just, when you're trying to settle a case in the field with the sergeant or the lieutenant, it's very hard to get them to give you a warning. And I know, you know, there was a big announcement made several years ago that, hey, all regulatory violations are going to be, you know, it's going to be a warning-based system. And I don't know if that policy has now gone away, but I don't really see that addressed in anything in 3410. You know, there's always the mitigation rules in both the public safety and the regulatory. But I can just tell you in practice, you know, I'm not seeing a lot of warnings being issued for regulatory or public safety rules, and whether that's just something that y'all can take care of internally or that needs to be in this rule, I don't know. But you know, I know that there was a big you know, pronouncement and public statements issued that at least on the regulatory side everything was going to be warning based. So that's my only comment.
Let me give Chief Kirkendall is here. Let me give him an opportunity to comment on that, because of course I don't know what's going on in the field, so appreciate him being here. Can you just scoot all the way over or speak loudly?
Okay, Victor Kirkendall, TABC Enforcement. You're correct. The intent is for regulatory violations for it to be a warning-based system unless there are extenuating circumstances that warrant it not to be, by exception. But public safety violations, because of the nature of their violations, typically are not considered warning unless there's mitigating factors. But we're striving to make sure, as far as any warnings relating to public safety, that all elements are there before a warning can be issued. I think there's an opportunity here to look to settle those through the field agreement waivers, and when it goes into AIMS, have those same rights conveyed to the permit holders before they even agree to a warning. So I thank you very much for those constructive criticisms.
Thank you, Victor. And I guess, you know, again, I understand the position was more, or the press statement, whatever it was more on the regulatory side. I just don't see any of that built into 3410. You know, it seems like you start straight to the $250, which again is not a lot of money. And I'm not really complaining about the ranges here so much. It just seems contradictory unless that is no longer the commission's policy.
I feel it is. I just don't know that we've captured that in the rule.
This is Edgar Korzanowski from Griffin and Hughes. There is one thing I wanted to bring up, and it relates to Chapter 34, and I forgot to mention, my colleague did. Although this is not in the rule, I'd just like to reiterate, you know, our request that the commission consider a proposed rule concerning time for hearing rights, statute of limitations, and also processing of original applications. There's a few examples that I could go over, I think, that illustrate the need of that. There was a case that the commission had recently had a hearing on. It was called Bilar El Tapatio. This is SOA docket number 458-21-2198. This is a minority-owned business that had basically been denied a permit, or effectively denied a permit for now the past 2 years, even though the administrative law judge dismissed the commission's evidence in support of the recommendation as speculative. There's little basis, scant, and described that the delays in processing the applications is appearing excessive. And he further stated that he lacked authority to consider rules on the constitutional challenges to the sufficiency of the TBC rules or the length of time to complete the hearing process. And so I think it's very, very important for all applicants, new entrants to the market, as well as those that have existing permits, are on notice of what those rules are, and that the commission also have reasonable standards for dealing with those things. We did propose a rule. It is available on our Griffith and Hughes blog, but the gist of it is we believe that there should be an up or down vote within 30 days somebody applies for a permit. If the commission believes that something is amiss, well, take care of it in 30 days, either approve it or deny it. And if you deny it, then set it for a hearing within a reasonable period of time. Another thing is that the commission not investigate complaints beyond 2 years, except in certain circumstances. We believe that the exceptions would be, of course, any subterfuge, unlawful use of a permit, any tied house, any human trafficking. I mean, these are reasonable. These are serious violations, and I think the commission should have unlimited period to investigate those kind of things. With regards to the back to the hearing, we think that the hearing on an original application needs to be heard within 90 days, and unless it's waived by the applicant. And again, the same would apply for any supplemental permits. Again, the reason for that is very simple. They need to be processed timely, and there's no reason to delay those things. If there really is an issue later discovered down the line, you can cancel the permit. You have injunctive powers. I mean, there's different ways to resolve that issue if it was later granted in error. We'd also recommend that any denial on a renewal occur within a hearing on the denial of a renewal application occur within 120 days. Again, it's a public safety issue as well as fairness to the permittee. If it's a bad business, justice delayed is justice denied. I mean, shut it down right away. Don't let it sit there and linger. We have some other suggestions, such as agency orders, that they're not slow walked, because conceivably, like as happened in the BLR case that I mentioned earlier, you still don't have an agency order, and that decision, if I'm not mistaken, was made in July of last year. And again, those things need to be happening faster. So I'll leave it at that. Again, anybody wants to look at those, they're welcome to see that at our website. Thank you.
This is Bill DeFore. I have an attorney. I represent all different levels. I do have had some computer issues, so I didn't get to make a comment on the warning issue. And I do want to echo the sentiments of Keith Coleman, in that when there is an inspection and there is something that they suspect but can't prove, they pop you with a warning. I'm going back 40 years plus dealing with agents, and I know this goes on, and I just want to re-echo that is a problem. And it's just that warnings are warnings. And when I first started discussing this with agents, it was always, well, this isn't going to be, it's not going to count against your permit, but we just want you to be aware so that maybe you don't do this or whatever. But to put this in the issue of counting it against your permit is just incorrect, because one thing, you can't fight a warning. I know other colleagues of mine have tried to do that. You can't do it. And so if we're going to be using warning as a violation, then we should have a chance to litigate that. And thank you very much for your time.
And maybe you guys can help clear this up for me, because this is actually not a change in our rules. That a written warning can be used as an aggravating circumstance, that you have the rights and procedures of a contested case under the APA. All of that was already there. So if there was something else happening, this is what's in the rules. So it's always been it's always been documenting a violation. It's always been able to be used as an aggravating circumstance, and it's always been subject to the rights and procedures so that you can fight it in the rules, at least. So if anyone has any insight that they'd like to share that can help clear it up for me, of course, I'm coming at this just 2 years now. Oh gosh, almost 3. Going from a rules perspective, and so I lack some of the perspective that you folks have. So if you have any thoughts on what that disconnect is, I'd appreciate it.
Well, and I will point out that we have not been able to contest written warnings in the past. So, and I know I've got another colleague who's listening right now who has had that situation, and they were not allowed to do it. Anyway, that was my understanding. So if we do have that opportunity, that's wonderful. Thanks.
Well, this is Dewey. My recollection is in the old days, when me and Bill were doing this, you got a warning, it was a ticket, it didn't count against you. You are right. The current rule states you can ask for a hearing, but I don't think in practice, at least in my experience, that has ever happened. Because it wasn't counting against you for enhancement purposes. So you had a right to a warning, but in practice, why would you spend the money to go to an administrative hearing if you're just going to get a slap on the wrist anyway? Because in practice, the warning wasn't counted as a first violation, which the way I'm reading this, it is. I want to say it was 5 to 7 years ago when that was added in to say, yes, you can contest it. It's, I don't want to say extremely recently, but within the last 5 to 10 years, I think is when that change was made, just for background, my recollection.
The aggravating circumstance, that's also in the current rule. So was that, do you remember if that was added at the same time?
I think so. I'd have to go back and look, but I want to say it was in the 2010s when that was changed.
Okay, I'll take a look at that. Thank you.
And Shana, just to clarify, the trap, I guess you're trying to inquire about what really is the problem. And the problem is if you don't have a appropriate waiver, then there's a due process question whether you could use that as an enhancement at a administrative hearing. So that's where the issue is. It's not that the TBC can issue warnings. I think the TBC has the full authority to do that. It's, again, how it's implemented. So.
Right, and yeah, we understand that. Obviously, we don't want to get stuck. We don't want to have people not understand what their rights are, and that's why we were talking about the ways that we could provide additional information, before people sign off on anything, and also, obviously, we would have to provide training. We talked to Chief Kirkendall about providing training to your field officers regarding, how this is supposed to work. And he felt like, that's something that would be feasible. So there's some challenges there. I get it, but it's not insurmountable. So all of your ideas on how we can protect the process, I really appreciate all of them. Any other comments or questions on 34 through 37? It is 10:45. We are halfway through our time. So if it's all right with you guys, subject to any last comments here, we can move on to Safe Harbor. And again, if you have comments that you weren't able to squeeze in today or fully articulate, there's no limit to when you can email me or give me a call. And we've got some time here. So if you call me within the next, couple of weeks, we'll definitely be able to take everything you're saying into full consideration. And hopefully y'all can help me out with some of the things that we've talked about, kind of clarifying and beefing up. With that said, we will move on to item 2. Item 2 is proposed chapter 49, actions of employer delivery driver not attributable to license or permit holder, quote unquote safe harbor, essentially. Last time we talked about this was October, and it's been a while. I've slept since then. But what happened in October was that, we had a lot of objections to the way the rule was originally drafted. And so we went back to the drawing board, essentially. I personally didn't like the use of the term of art rebuttal presumption because it implies that there is a burden of proof on the respondent with regard to certain elements. And so I wanted to remove that. And starting from that premise, essentially what we've done, and this is really about 49.3. Of course, we'll talk about the whole chapter, but this new 49.3 regarding actions of employee not attributable. So in consultation, obviously, with our enforcement staff and litigation folks, what we have tried to do here, and what I think this rule does as rewritten, is to first of all remove that term of art rebuttal presumption, because we don't want to imply the respondent has a burden on the third prong of the safe harbor qualifications. And then second, it makes clear that evidence of compliance with the third prong is not required to be produced by saying, you know, these are things that we find relevant, but not you must produce anything on that list. And then third, it gives a kind of a handy non-exclusive list of things that the respondent can choose to provide in aid of settlement. These are not new considerations. This is just the types of things that we have found relevant and our attorneys have found relevant in the past in determining whether we want to pursue a hearing on a case, safe harbor case, based on our, you obviously have to weigh your probability of success on proving that third prong. So if you are a respondent in one of these cases and you have some of this information and you choose to bring it to us, obviously you don't have to, but if you choose to do that, that's a way of avoiding having to go through the expense and the trouble of a hearing, because our attorneys and folks generally find that persuasive on that third element. Again, you don't have to do it. You can force us to go to hearing. It's our burden of proof. I just think that there are probably a lot of folks that would prefer not to go to hearing and have this kind of information that's helpful to our folks being able to get to a place where they're comfortable with settlement and not going to SOA. And again, we can, I mean, this isn't things that we've never considered before. It's just providing the list in a rule, which is an increase in transparency, and it's a non-exclusive list. We can consider anything as proof, and you can provide anything that you would like in aid of settlement. So that's what we intended to do by kind of flip-flopping the rebuttable presumption. And I think that's what we achieved, but we've gotten a lot of feedback already on it. So let's open it up. Let's talk about 49.3 first, and then we'll go back. I know there's probably gonna be some other areas of comment, but let's start with 49.3, which is the kind of brand new reimagined actions of employee not attributable. And again, if you'll unmute yourself, say your name, who you represent, and make your comments, and go for it.
This is Edgar Korzanowski from Griffith and Hughes. I'm going to start with 49.3D, subsection D, and subsections E2, 5, and 7. Here's where our concern is. So the commission is essentially calling this a, you're getting rid of this rebuttable presumption to take care of a burden shifting, but that's not really accurate either, because subsection F under the existing rule 34.4 says there is a rebuttable presumption that a license or permit holder has indirectly encouraged a violation of the law if the commission presents sufficient proof. Okay, so that is a burden shifting when you start getting rid of the rebuttable presumption. Now, I understand you're saying that that's not the intent, but that is the way that it appears. Another thing that we have concerns about is what is 106.14 and how is it interpreted by the courts? Well, the courts basically interpret, and I'm talking about courts of record, they basically require two things to be shown. That the retailer must present evidence that the employees are required to attend the solar server training, and this can be proven by affidavit, and that the person who actually violated the code had valid solar server certificate at the time. And this is the law. this is all that is required. But the way that the rules are drafted, it basically says, you know what, we're going to impose some additional restrictions on you if you want to settle, because if you don't want to settle, you're going to be going to a hearing. And so those restrictions are that you need to present, or the retailer needs to make sure that within 7 days of hire, the new hire, presents the seller server certificate, which is shorter than the 30-day rule currently. Then there's also this requirement that there's not any lapses in seller server training within 24 months. So God forbid some employee had missed 1 day, then the whole business is disqualified. I mean, that's ridiculous. Then there's another one that says that, that the retailer must present evidence in the case of solo employees that they are seller server trained before they go out on the floor. So if they are seller server trained on the date of the violation, that's not good enough. They need to have seller server training well in advance. Another thing is this affirmative requirement that retailers, adopt written policies and procedures to demonstrate that employees read them and understood them, and that retailer essentially must disprove direct or indirect encouragement by showing compliance. Now, again, I understand settlement. You guys can ask for anything and everything, but what you're doing here is you're establishing a higher burden for eligibility for safe harbor than what is required under the law. So in essence, you are imposing additional burdens on a permittee. And again, we don't believe that this is appropriate in light of what the law is. And then the other thing is, what happens at hearing? Naturally, the commission is going to say, well, Judge, we already required those things. It's not that big of a deal. It's in the interest of the business. Well, then you have created a de facto requirement that there are these additional burdens that are not required under 106.14. If the commission really wants to fix this problem, get rid of this revised statute. There's nothing wrong with 34.4. It's very clear what is required, and we'd ask that the commission consider the same. As far as prior arguments in support of these things, I remember hearing that, oh well, businesses, they have all the records, they have all the information. Well, TABC has 240 agents. They have over a dozen attorneys. They have subpoena powers. They have powers to go and punish a business who don't provide documents. You can ask for them. You issue a ticket, settlement conference, quick question. Hey, do you guys have any evidence of this? Yeah, sure we do. Turn it in, not a big deal. And if the commission isn't satisfied with what they see, not a problem. Say, you know what, we're going to go and take this to hearing. But to put these as affirmative requirements, essentially, I think it's an issue. And I would like to add also that these aren't a suggestion. I can tell you how it works right now. If I have a case where I submit a safe harbor affidavit, which I can lawfully do, and the next response from the commission is, I want to see every seller server certificate of every employee that's involved in the sales, service, or delivery of alcohol. Okay, and if you see a certificate that's expired or is missing, you won't allow safe harbor in the field. So for all basic purposes, you are mandating this as a requirement, and this increases the cost of litigation.
Hi, this is Dewey Bracken. I mean, this is a much better draft than we had last time. And I mean, I don't think Edgar's wrong as far as in practice what happens. I mean, he's correct. You can do your seller training affidavit, and then immediately a request comes to provide all this information. Yeah, to me, it just comes back to the Slick Willie's case, which I think I cited last time. I can give you the site, but it's that Supreme Court case. And I mean, it basically says once the permittee, in this case, can requires its employees to attend, and the employee in question had actually attended, then the commission's got to show the direct or indirect encouragement And it's just based on the, facts and circumstances of that employer, right? And what they're getting at in that case is, are bar owners going out there and saying, everybody go ahead and get seller trained, and then wink, wink, nudge, nudge, do whatever you want because now I have to get out of jail free card. I mean, I think that as a prosecutor, as a former prosecutor, that's what you would have to prove to make your case, that there's some kind of wink, wink, nudge, nudge going on behind the scenes, not to Edgar's point, some of the niceties of this rule. Oh, you had one guy that had a lapse, 3 years ago, and therefore you don't get to get out of jail free card. It just turns into this super ticky tack. We found one thing and now we're not going to settle, and now you're going to have to go to court and we're going to have to prove our case, and then you're going to have to prove the safe harbor elements, which is fine if that's what it comes to, but I don't think that's what the Supreme Court had in mind when it interpreted the statute. Thank you.
And obviously we can't change, and we're not trying to change what the Supreme Court held or the elements of the statute or the burden of proof. And this is actually drafted very much with that case in mind, that, we literally track the statute exactly in subsection C, and then subsections D and E are as a non-exclusive list of factors. We're not saying that you have to have any of these factors. You may have other factors. This is just some things that we think are helpful. And then same for the settlement, the prima facie evidence of compliance with subsection C1. We can discuss further internally whether we think that's too strict or but that's a may. It's not a shall. It's not a if you don't give us this, we can't find that we can't find that you've met your burden. There's nothing about it that's kind of a sudden death. If you don't do this, then you're screwed.
I mean, I agree. It's a great improvement on the first draft. So to me, it's just more you should really be focusing on, are people trying to use this offensively and then letting people go off the reservation because they've made this prima facie case on the bar end, versus here are all these elements that we might decide as an agency that you don't get it. So, but again, vast improvement from the first one. Thank you.
Go ahead.
The idea behind the subsection E was that, it was actually to be an aid in transparency. I mean, essentially what we're doing is laying out in a rule the things that people at our agency are going to be thinking about when they say, okay, well, do we want to take this to hearing? Do we think they directly or indirectly encouraged? And for that reason, we need to go to SOA. These are the kinds of things they're looking at. Well, did they have a, they advertise like a buy one or, all you can drink or something like
Do they have
that.
practices that violate
Right.
on-premise promotion stuff?
Right. Okay.
Did they
So
put in written policies? And have
do they have
employees
no
understand it?
policies? Do they have, if they have no policies, they have all these, these crazy promotions that they do on a regular basis, things like that. Those are things that are illustrative of whether the actual, permit holder has any sort of culpability for the problem. But in no way is it intended to say, if you can't give us this, then, we're definitely going to take you to SOA. You could have other things that are helpful. We could decide that we just don't have a very good case. We don't have any real way of proving that you directly or indirectly encouraged. If what you want is for us to just strike this section entirely, I think all that does is remove some transparency. But, if you disagree, please feel free to say so, or send me an email and explain to me why that you think that this is going to effectively be requirements.
And Shannon, this is Edgar from Griffith and Hughes. One of the ways the agency can and does engage in transparency is by issuing industry bulletins. And that's fine if you're trying to say, here's our factors that we consider. And And that's not imposing requirements. You're just saying these are factors we consider. And it's a very neutral way of saying, this is what we look at when we evaluate safe harbor. And I think that's absolutely fine. But what I'm concerned about is whenever you're putting it into rule and then you couple that with your striking language about who bears the rebuttable presumption, it appears that now you're imposing these requirements because it's already part of the settlement process. And oh, you don't meet it during the settlement process, then it's very easy for the agency to argue and say, look, we already required this for settlement, judge. They didn't show it at settlement and they're not having it here at the hearing. Therefore, you should find in favor of commission. And that's the danger with the way the rule is written. And so we would ask that the commission strike this rule and just keep 34.4. I think it provides a fair balance. I think you can add, if you're concerned about uncompensated employees, distributing alcohol at the premises, just put in whether compensated or not, including but not limited to independent contractors. That's fine, because I think that is covered under the exclusive occupancy control provisions of the code under 10953. Thank you.
No, it's a good. All right, go ahead.
This bill before, I have section 40 in 40, and I guess you might come back to this, I'm sorry, but this talking about incidental employee, how do you look at, how are we going to advise clients when we have a company that has like a CEO, multi locations, because when you define what an incidental employee is not, is anyone that sells, service, delivery, storage, and transportation, or any management or supervision of such employees. That's going to hit like CEOs, Charlie Butts, head of I mean, is that where you're going with that, or is that just maybe an oversight, or how do you look at that when we have multiple locations?
Talking about a concern, I guess, for people that are going to be officers of the entity that aren't really focused on the day-to-day management of the actual alcoholic beverage business, just like an on-site manager would be, and them getting caught up into this.
That's what I'm talking about. Yeah, because you have people that you're going to have a home office, and that's where you're ordering and all the different things, collecting money, doing all the things that you do, but you're not actually in a store. But the way that, but obviously they're managing each of those locations indirectly as being the head of the agent or of that company.
Can I?
Go ahead, David.
Yeah, David, do you want to?
Yeah, if I can, our thought in this when we came up with this definition of employees and then I guess an exception or cutting out incidental employees was to actually help the permittees in this regard. And what we're trying to do here is define it in a way that like the restaurant manager who's directly managing or supervising the employees that are serving alcohol, he's included. He's included as an employee, but not the CEO who's not directly managing the employees. So, for instance, one of the examples I give a lot of times is, we certainly don't want to include in this the gardeners or the plumbers who have nothing to do with serving alcohol. So likewise, but we do want to include managers who are responsible for those employees who are serving alcohol. So the store manager at that site, yes, he's responsible for those employees.
Well, and that's understood. I mean, that's not, to me, I understand that because, we've all, even in the past, David, we've, is it the cook? Is he doing anything with alcohol? No, he's not. Okay, we understand he normally is not certified, which is fine. I guess it's just that when you stretch this out, it maybe not you guys, but it could be interpreted that, gee, you're the CEO, but do you go around and check your stores? Well, yeah, I do. And we do this. And that's what I'm saying.
If you can find a better way and send us what you think might be a better way to word
okay.
this, so that
we'll work on that.
we want to include the direct supervisors, but no, not the CEO who might
Yeah,
take.
and I understand that. I mean, I think anyone that's in that location that's the GM or whoever's in there. I mean, I always have everyone, at least I try to have everyone seller certified that's actually in the location to take all this away. So
Right.
anyway,
Now,
we'll do that.
Granted, sometimes this is going to be fact specific to the way that a particular place operates. For instance, if you have a district manager who goes around from store to store and has a lot more hands-on supervision, then maybe he ought to be seller server trained. I mean, I can see places where you have some chain and a district manager comes in and actually gets behind the bar himself every now and then.
And I agree that's not where I'm really going on with the top people. I guess that's
where we would be happy for you to see if you can tweak the wording in some way that alleviates your concern, but still, helps us to make sure we're getting the right people trained.
Yeah. Oh, and I will add also, Bill, if you take a look at the definition of employer, I mean, we thought that we started to kind of address this potential issue by putting those people into the category of employer, making that clear that it's not going to be considered someone that needs to be trained like the employee. But if you also think that doesn't fully get us where it needs to be, then we'll continue to look at that and see if we can make it a little bit better.
Yeah, and I think probably where we want to make the changes might be in the definition of employee, just to make sure that we're excluding those folks from being employees at all. We don't want to make them incidental if they're the CEO, but we might want to say, okay, well, that's not, when we're talking about employees, that's not who we're talking about.
Well, and a lot of time the folks at the top are an employee as far as maybe being paid or something like that. I don't know, but I'll see. We'll come up with something.
Yeah, that's why we came up with the incidental employee thing, because you're right. The CEO, he's an employee, and so we need some way to create an exception for that CEO. And that's what the idea of incidental employee was supposed to, among other things, cover, but certainly would be happy to look at your suggestions.
Okay, thanks, guys. Appreciate it.
This is Andrew. Oh, go ahead.
Shana, this is Lance with Texas Package Stores Association again. This particular subject is concerning to us for the reasons mentioned prior to me, certainly with the CEO designation and things like that. I would even submit to y'all that a manager of a store, let's say you've got a Walmart and they've got 125 lanes. Are we blaming the manager because he can't keep an eye on 125 cashiers at once? Focusing the blame on who actually hands over the product, I think is of concern to us. So again, just going to echo what's been said. I would even take it a step further, and let's try to focus the point of this on the person who actually violates the law, instead of the people who are above them managing janitors, gardeners, as was said. So we have a lot of concerns about this. Happy to work with y'all, and obviously, if this is something that needs to be buttoned up via legislation, I'm not opposed to trying to go that route as well. But just know we're ready to work with you on this one because we do have a lot of concerns regarding this subject. So thank you.
This is Edgar Korzeniowski from Griffith and Hughes. I'm just echoing some of the current concerns from Lance and Bill. I think one, the definition definitely needs to be tightened up. I think it's unnecessarily complicated under the existing Rule 34.4G. It really captured most situations, other than maybe there's an arguable question whether it got uncompensated employees or not, or if there's the language, somebody says, well, they're an independent contractor, they're not really an employee of the bar. And so my suggestion would be, first of all, fix that so it mirrors more or less 34.4G and then just takes care of any gaps. So one possible solution could be employee, any person, whether compensated or not, who is involved in the sale, service, dispensation, or delivery of alcoholic beverages, or is immediately managing, directing, supervising, or controlling the sales of alcoholic beverages. And again, I would focus on the immediate part. But, as Lance had mentioned, and this is just the concern, well, what do you do with the 100 lane type situation? Well, you look at, there's a case, Parker, I think I've cited this many times before. Vice principals are generally not, they're not entitled to safe harbor protection. So if you have somebody that's high up in the food chain, has authority to hire and fire, conceivably, if they committed a violation of the code, they're not eligible for safe harbor. The business is not eligible for safe harbor. It's as if the permittee actually committed the violation. And so why would you impose, seller server training for those things when they couldn't benefit from it if they're in fact considered a vice principal? So I just want you guys to take that into consideration.
This is Amy Harrison Consulting. I'm just curious, and with David and Victor joining us, statistically, what is the agency seeing? How many of these tickets are you writing? How many of those are being settled because people are able to provide this documentation? If they're not able to be settled, why is that? And what's the result? What are you all seeing globally out here with the rest of us? Because our situations are one-off. What are you seeing?
I think that's probably a question for David, potentially. Do you have any information on that?
Yeah, unfortunately, I wouldn't be able to answer that question just for the background statistics on those types of cases.
I don't have any statistics either, but I feel like it's very infrequent as far as being that critical. Like if all the intent.
I don't have any statistics either.
It might be beneficial for someone to get those statistics and see, what's the reality of what's going on.
This is Edgar from Griffith and Hughes. I do have some comments shifting gears to 49.3E. We're back to the safe harbor safe harbor rule. I do want to kind of bring your attention the differences in how the current rule and how the new rule works, because it is concerning how easy it is to disqualify somebody from safe harbor. First, under the old rule or the existing rule 34.4D and subsection E, basically you need to have 2 prior adjudicated similar violations within 12 months of the current offense. So again, very important, there's an adjudication, there's a waiver agreement, an order, or there is a proposal for decision in an agency order. Whereas under the proposed draft rule 49.3, I mean, it's basically doors wide open to disqualify somebody from safe harbor, basically making it meaningless. And let me go over them. So first of all, under this, you can have 2 incidents alleging either sale to minors, sale to intoxicated person, or open saloon within 12 months, even if unadjudicated, or there's a dissimilarity to current offense. So for example, current offense is, let's say open saloon, the other one is sale to minor that's still pending. I mean, these are things that the commission is allowing now for consideration, whereas it's not an automatic disqualification under the old rule. Another is this 3 incidents of any kind within 24 months, even if unadjudicated or dissimilar to the current offense. And then you're also opening the door to allowing any other relevant evidence, even if unadjudicated or dissimilar to the current offense. Here's where, we see, big issue is you could have, say, a restaurant that's cited with sale to minor. And because in the 12 months, they had 2 warnings for, say, credit law violation. And the principal officer on the permit had an unadjudicated speeding violation. You could very easily say, no, I'm sorry, you're not eligible for safe harbor because permittee has money troubles and is aggressive and therefore must be encouraging employees to look the other way as evidence of indirect encouragement. I mean, I'm not saying that the commission would necessarily do that, but it's certainly something that they could do selectively. Our suggestion would be to just readopt Rule 34.4, except for a subsection A. This is the thing about requiring the safe harbor affidavit. You know, as a practical matter, this isn't necessary. It would be brought up at the appropriate time very early, especially during settlement negotiations. And it just, again, presents a trap for the unsophisticated or unwary permittee. Thank you.
Marcus Shorts here. Going to definitions in 49.2 for incidental employee. I'm concerned about storage and transportation. You know, to me, what does storage have to do with public safety? You know, I'm thinking of, you know, okay, beer distributors bring in a bunch of kegs. They block the lettuce. The cook has to go in and move around the kegs to get his lettuce out so he can make a salad. That's involving the storage and transportation because he's moving the alcohol from point A to a different point B. And potentially now he has to be seller server certified. I think how it's written, it's very vague. And I don't see the need for storage. For transportation, I get. I think you're trying to go for, you know, delivery and transportation off the premises. So maybe you say something about transportation off the premises, not just transportation, because otherwise then you have bus boys, right? Who have nothing to do with the sale or service, but they're emptying some beer into a trash can. Well, they're transporting alcohol if it's half full.
Yeah. Okay. Thank you. Marcus, you actually hit on some of the stuff that we've been discussing internally, especially with the transportation and making sure that that could cover people that are kind of delivering off premises and everything. And I will say just the terms for storage and transportation are something that we are still discussing. So your comments do not fall on deaf ears at all. We understand that those could be construed as being extremely broad and maybe trying to account for employees that we're not necessarily wanting to account for because they're not really dealing with anything at all connected to the sale and the service of the actual alcohol. So that's definitely something that we're going to continue to look at and see if we can kind of finesse that language and make it a little bit more clear.
I appreciate that. And my only other comment, and Shana, I think we talked about this, but in 49.5, there's that, I think, misquote where it talks to consumer delivery, and I think you meant to do the 3 violations. So thank you.
Fix that.
This is Edgar from Griffith and Hughes. I want to move on to 49.4D. This is the consumer delivery permit. There's a subsection here that talks about that that the consumer delivery permit may establish a rebuttable presumption that has not directly or indirectly encouraged the driver to violate the code. That's not an accurate statement of the law. That statute parallels essentially 106.14, and 106.14 has already been interpreted before that the burden of proof is you show the seller, not the seller, but the driver certification and that they completed compliance with the software application. They're presumably eligible for safe harbor. They've established a prima facie case. Doesn't mean that they're automatically going to get it. It just means that the commission needs to disprove the eligibility. And so 49.4D really is just, I think this is invalid. I would consider or propose that the commission adopt 34 something along the lines of the existing rule 34.4F and H, and just say something to the effect that there's a rebuttable presumption that a license or permit or holder has indirectly encouraged the violation of the law if the commission presents sufficient proof that the permit holder fails to meet any of the standards set forth in the paragraphs of 1 through 3 of the subsection, and that the burden of persuasion shifts to the permit holder's shoulder, it is not indirectly encouraged a violation of law. So just ask that you take that into consideration. I do have a comment under 49.4E, but I thought I'd pause and see if you wanted to respond to that.
We will take a look at that, but I do believe that some of that language in the subsection D that you're talking about comes directly from the statute in chapter 57, but we'll double check and make sure that that aligns exactly with the language that the code is using.
Okay, thank you. And I do have a comment under 49.4E. This has to do with attribute or the rebuttable presumptions. The draft doesn't describe what that proof is. It doesn't use language such as same type of offense. And so our concern is that anything and everything potentially could be used to I don't know, defeat safe harbor. I would propose that the commission consider, again, similar language under existing section 34.4, which has requirement they produce final orders, that there were in fact violations for the same or similar type of offense. I mean, if the commission wants to use a 3-year period instead of, I'm sorry, a 2-year period instead of a 12-month period, I mean, that's the discretion of the commission. I think that's fine. But we'd ask that there's actually proof as opposed to just allegations. Thank you.
This is Bill DeFore again. I think you guys might have talked about this, but in 49.3D, and excuse me if I missed it, but are you saying that every employee, that they can't have a, you know, we can't have someone that had a seller server certification for 12 months, then for a month they didn't, then they got it the next month? Are you saying that that is going to keep us from being able to say that they have attended a seller server course?
In subsection D, no. It's somewhat of, I guess, the opposite. We're not trying to create requirements that, you know, must be done, but we're trying to set some sort of threshold that lets industry know, if you can meet this and do these things, you're going to be able to get safe harbor, and you're going to be able to either you're going to be able to meet the requirement, actually, sorry, in subsection C3. So
but shouldn't it be that on the date of the violation, if everyone is seller certified, and I mean, I understand that the seller certification only lasts for 24 months, but I mean, it kind of implies that they can't have any break in the chain in that 24 months. Am I missing something?
No, and that's, I had made a note next to D, just it's a too strict question mark. I think that's something that we're going to revisit as a group. Again, this is a higher bar than you know, the employer requires its employees to attend a seller server course. That's the statutory, that's what you have to prove. But we're saying this is a higher bar, but if you can give us all this stuff, then we are satisfied that you've done that, and we will, you know, we'll move on from that particular prong. But if that's, you know, if that's going to be virtually impossible to meet, then maybe we need to revisit that and see if we can address those concerns.
Well, we you know, we have a lot of employees that, you know, they forget to take it, and then there's always a lapse. I mean, it's just to remember 2 years later, a lot of times there's always a lapse. I mean, I understand that everyone has to be seller certified on the date of the event or the offense, and that's always been the case in the past. If they're certified, then we're good. So anyway, thank you. And I do want to say that this isn't like we're all pounding on you guys. I mean, we've been, a lot of us have been around a long time, and have a lot of experience with all this, but we do certainly appreciate the fact that we get to do this. So I just want you guys to know that.
And I certainly appreciate that too. And that's why we have these meetings, is because like you said, you know, there are definitely gaps in my knowledge, and just by virtue of, you know, sitting here in headquarters, and so it's really incredibly useful to me, and informative, and increases my knowledge, and I really appreciate it. And just so y'all know, I never feel attacked. I'm, you know, this is my job. So, and I actually started out at TCEQ, and when someone wants to put a wastewater treatment plant in your, you know, backyard, people are a lot meaner. So you guys are lovely, and I appreciate all of your input, truly.
Well, Shana, you've never met a bus full of folks from East Texas that want to keep out a bar. I'll tell you, it's a sight.
I can imagine. Okay, we are running out of time. We've only got a couple more minutes. If you want to make a quick comment now, go ahead. And if we run out of time, again, my door is always open. This is not your only opportunity. And I would love to get any comments that you have not already provided me in writing. Please shoot me an email, just kind of summarizing what your primary point is, and then maybe some suggestions for how we could amend the rule that would address your concerns. So any last comments or thoughts? See, Marcus, you're unmuted.
This is Amy.
Apologies.
Go ahead, Marcus.
That was just me not hitting mute again. So, go ahead, Amy.
Pre-Ames, the agency had the ability to calculate the percentage of permit holders that were reporting seller server training, that their employees were seller server training. I don't know what that situation is post Ames, but I think that statistic would be important, because in the past it showed that the majority of the industry was very educated in that requirement, and that they pursued that sort of training for their employees. So I think statistics would be beneficial in this situation. And just to know how many of your licensed permit holders actually participate in seller server training. What is that number?
Amy, this is Victor Kirkendall. I am aware of a system that did capture how many people statistically was seller server trained, but I don't know that we've ever captured permittees, businesses that had their employees seller server trained. Can you clarify or provide me insight where that information might have been held before?
It
and just
was
get you an email. I know everybody's trying to get home.
Yes, and you know what, Victor, I will email it to you, because it was captured in the old system. So I'm happy to give that to you, because I know the legacy system is still available to you, and perhaps you could get some of those numbers.
Excellent. Thank you.
Thank you.
All right, 11:30 on the dot. And we will go ahead and wrap up. I'm not seeing any unmuted or raised hands. So thank you all for this discussion today. It was extremely useful. And we hear all of your concerns, and we are going to spend quite a bit of time on them in the coming weeks. So again, please continue to engage with us, and we will same for you. And with that, we will go ahead and sign off, and I hope everyone has a lovely weekend.